We consider this case against the background of a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. There is no exclusion for the judiciary that makes judges or court staff immune from profane, caustic, demeaning, inflammatory, or sharp criticism by a citizen on social media or in correspondence. The arrogance of such tyrannical assumptions as to believe themselves that far above the Constitution of the nation and this state is staggering, to say the least. Basically, this case exists in the first place because I criticized the judiciary and they got butthurt about it. And so they violated my rights as a result of it. And now they're asking once again, well, now this case should be dismissed. We already violated his rights for his free speech and free press, but now we're asking the federal court to also violate his rights to free speech and free press because he continues to engage in free speech and free press. I got some awesome updates today, though. Well, I mean, awesome. It's always an awesome update when we update stuff on the 7th Judicial Court, which I've been suing. I will start with a quick rundown of what's gone on with the 7th Judicial Court so far. Sometime in January 2023, I exposed a crooked, lying hearing officer in the 7th Judicial Court in Torrance County, New Mexico, and I posted it on YouTube. The individual who was exposed was Gordon Bennett. People like you viewed the videos of this crooked hearing officer and called the court demanding that he resign. He did resign. Following his resignation, Mercedes Murphy, Shannon Murdoch, and their court clerks got super sad and butthurt and banned me from the courthouse for exposing their crooked hearing officer with no due process whatsoever. Just said, you know what, you've exposed our corruption and our crimes, and therefore you can no longer come to the courthouse. I filed a lawsuit against the court for violating my rights to free press and free speech by banning me from the courthouse directly in retaliation for me publishing videos about them. A number of other things that they listed that I did that resulted in me being banned was criticizing Judge Mercedes Murphy, Judge Shannon Murdoch, and some of these other crooked elected officials. These judges and lawyers that are trying to violate my right to tell you guys what's going on, they get really butthurt that I talk about them and that I use their names and that I show their pictures. And so let me talk about this guy right here, because the opposing counsel and judges get really mad when I talk about them. They're like, you're doxing. Well, let me dox Blair Dunn here for a minute. You see this guy right here? I know since the beginning of the show, you guys are probably thinking, but James, who's the good looking guy on the screen there? That's what we want to know. That's Blair Dunn. Blair Dunn is licensed. He's the attorney that's representing me and actually has the set to go after these crooked judges. Blair Dunn is licensed to practice in New Mexico and South Dakota, representing clients in state and federal courts. He is particularly skilled in federal appellate practice, handling cases in the Court of Appeals for the Federal Circuit, the 10th Circuit, and the 5th Circuit. As a civil rights attorney and a lifetime libertarian, Blair is passionate about fighting for civil liberties and defending the rights of individuals. Now, I gotta say, man, I've heard this about a good handful of attorneys before and then had my personal experiences with them and said bullshit. Blair Dunn is by far the absolute best attorney that I have ever worked with. Some of these guys, most of these attorneys, they just don't get it. They really don't. They went to law school and they learned how to file papers and file motions, and they learned the process and the procedure, but they don't get it. And that's how Blair is different and how he stands out among all the others, and likely why he was awarded top attorney in 2020 and 2021. Just for the opposing counsel and the crooked judges, it's not as if we're only telling the world who you are. Look, we're all out there. I'm James Springer. I go by an alias, Jamesfreeman. This is one of my attorneys, Blair Dunn. I have a second attorney on the case, Zach Cook. And you guys are a bunch of crooked POSs. Mercedes Murphy, who's a judge, not just an attorney. She's a bar member. She's an attorney. She should understand the law. But besides that, she's a judge. She's making judgments and legal determinations in cases here in New Mexico every single day. And her ignorance to the law is absolutely astounding. It is absolutely shocking. It is absolutely disgusting. And this woman is an elected official who is making decisions every single day, legal decisions that sometimes permanently affect people's lives. She shouldn't be on the bench at all. At some point during this lawsuit, they offered me a sweet settlement deal. They offered me the deal of a lifetime, which I did a live stream here about. They said, James, if you will stop exercising your natural God-given rights, we'll stop maliciously attacking you. It was a smoking offer, I know. And most of you would be like, well, James, why didn't you just take it? If you will just stop exercising your rights, if you will just stop criticizing your government within legal means, if you will just stop making it, exposing us, we'll stop attacking you, James. And I said, gosh, it's a really, really sweet offer. Attorney Jade Delfin and Mercedes Murphy and Shannon Murdoch. That is a really, really sweet offer. But no thanks. No thanks. We've gone back and forth with different motions. I've shown some of them on my other channel. Is this not somewhat entertaining that we have a sworn, trusted, elected official, multiple sworn, elected, trusted officials, judges? They are supposed to be like, in growing up, I always kind of thought they were like the elite of respect and honor. And to see the way that these people are acting right now is like, it's cringe. Recently, Jade Delfin, the attorney for the 7th Judicial District Court that's defending them against my lawsuit, filed a motion to dismiss my lawsuit, and she asked for it to be dismissed. So in their motion to dismiss, they said this case should be dismissed as a sanction against James Springer, aka Jamesfreeman, as you guys know me, as a punishment for James calling the judges not nice words publicly on social media. I referred to their representation, Jade Delfin. I referred to her as a bitch on one of my YouTube channels. I called the lawyer a bitch. And she literally wrote in a motion, James's case for his rights being violated should be dismissed by this court because James called me a bitch on social media. These are attorneys. These are people who are supposed to know the law. These are people who are supposed to understand free speech. And Blair Dunn just wrote this response to the motion to dismiss. Blair wrote, as James Madison once said, and by the way, this whole case is about the First Amendment, really. It's about them retaliating against me, kicking me out of the courthouse and saying you can't ever come back because you've divulged information to the public that the public is entitled to, which made them mad and caused people to call us mean names. That's what this whole case is about. As James Madison once said, our First Amendment freedoms give us the right to think what we like and say what we please. If we, the people, are to govern ourselves, we must have these rights, even if they are misused by a minority. It remains clear that defendants maintain the idea that immune from public criticism or free speech of the First Amendment as applied to the states under the 14th Amendment. The First Amendment does not, in fact, apply to the judiciary. But as public elected official or employees, there simply is no basis for that assertion. Thus, it bears repeating for the sake of the defendants. The First Amendment, which certainly applies to the states unequivocally, requires that judges for the 7th Judicial District shall make no order abridging the freedom of speech or of the press. U.S. Constitution Amendment Number 1. Instead, defendants' instant motion lays bare that they are entirely motivated by being offended by the content of the plaintiff's speech, which calls them names, mocks them, satirizes them, and calls into question their honesty and competency. And that is the driving force behind the defendant's actions to abridge plaintiffs' rights to free speech and free press without any pre- or post-deprivation procedural due process. Thus, plaintiff's complaint alleges facts which must be construed in plaintiff's favor, even if disputed or recharacterized by the defendants. They constantly characterize and in their motions say that what I am doing is misconduct. They don't claim that I did anything illegal. They don't claim that I broke any rules. It's just in their words and in their interpretation that what I do is misconduct. And to them, misconduct means not doing everything we say every time we say. Even outside of the courtroom, none of this has actually occurred inside of their courtrooms where they actually have jurisdiction and control. It's all happened outside. And they are trying to control me and you guys everywhere, including in our own homes. You guys in whatever states in the US you're in or whatever country you're in, they are trying to control every single one of us in our daily lives, telling us what we can and can't say about them. This just gets worse and worse every time they open their stupid mouths. However, overarchingly between both of the motions in the defendant's outrage over the content of what the plaintiff has said about them in their official capacities as elected officials or government employees obscures their ability to recognize the wisdom of Justice Brennan. We consider this case against the background of a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. Quite simply, there is no special exclusion for the judiciary outside of the powers of contempt to maintain decorum and judicial operation in the courtroom. Outside of that, there is no exclusion for the judiciary that makes judges or court staff immune from profane, caustic, demeaning, inflammatory, or sharp criticism by a citizen on social media or in correspondence sent to other government agencies. And again, the defendant's instant motion quite literally boils down to asking the court to punish the plaintiff with dismissal of the case for calling them in their capacity as public officials names that they don't like, or exposing their alleged incompetence / corruption to the public. The arrogance of such tyrannical assumptions as to believe themselves that far above the Constitution of the nation and this state is staggering, to say the least. To be sure, public office or public service is not for everyone. It requires an individual with the capacity to take public criticisms, no matter how sharp or caustic they may be, and continue to perform their job to the best of their abilities. There is no recognized exceptions for individuals who are elected as state court judges or hired in the state judiciary. True, inside of the courtroom, judges enjoy special powers or privileges to moderate the conduct of litigants and counsel appearing before them. And legal counsel is bound by special rules that dictate conduct of attorneys towards the judiciary, even outside of the courthouse. But Mr. Springer wasn't a litigant before the defendants any more than he is an attorney. And outside of one instance of videotaping without permission inside of the courtroom and failing to abide by the now discredited and defunct mask mandate, none of the complained of conduct by defendant Mr. Springer falls within the defendant's authority to regulate his speech or press. Yet the defendant persists, and in so behaving they continue to aggravate their situation with the public that is unhappy with them based on Mr. Springer's reporting. The instant motion is no different. It will be reported on and read by Mr. I've read most of the motions on the smaller channel, the Fake News Network. I've only read a little bit of it here, but he even puts in this motion. This will be reported on and read by Mr. Springer to his nearly 500,000 subscribers, who will again likely be incensed, not in great part by his profanity or commentary about the motion, but rather by the audacity of the defendants and their counsel to remain so tone deaf regarding the abridgment of violations of freedom of speech, press, and even petitioning for redress that defendants have perpetrated against Mr. Springer. Even this court appears to have, in some part, been influenced by the external pressure to address Mr. Springer's actions in an affront to the judiciary, both state and federal as a whole. The Supreme Court has been clear since the 1960s. The concerns over caustic speech or reporting must be decided in favor of public debate. instead of the public officials' concerns. The interest of the public here outweighs the interest of the appellant. The protection of the public requires not merely discussion, but information. Political conduct and views, which some respectable people approve and others condemn, are constantly imputed to congressmen. Errors of fact, particularly in regard to a man's mental state and process, are inevitable. Whatever is added to the field of libel is taken from the field of free debate. And so we now find ourselves with this instant motion which asks this court to punish plaintiff for the content of his speech, but which offers no explanation for why plaintiff's speech and reporting is punishable instead of protected, outside of the fact that it is directed towards government officials that are members of the judiciary. Thus, far from plaintiff stating a claim upon which relief can be granted, defendant's second attempt at a motion, which is largely the same as the first, falls short on all fronts of requisite showing of Rule 12 dismissal under blah, 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 blah. These judges are asking the case to be dismissed because I continue to criticize them. Basically, this case exists in the first place because I criticized the judiciary and they got butthurt about it. And so they violated my rights as a result of it. And now they're asking once again, well, now this case should be dismissed. We already violated his rights for his free speech and free press, but now we're asking the federal court to also violate his rights to free speech and free press because he continues to engage in free speech and free press. In case you guys are wondering who you are paying to fight this case, you guys who are watching right now, it's coming out of your pocket. You are quite literally paying for Jade Delfin to continue to write motions saying that my case against the government should be dismissed because I continue to exercise my rights. You are paying Jade Delfin to do this. Therefore, if you have anything to say to Jade about that, you can reach out to her. That's your right. I would urge you to keep it legal. Threats of violence are not legal. I would genuinely urge you to keep it legal. But I would never, ever, ever urge you to stop criticizing your government and stop redressing your grievances.